Good morning. Are you Eric Seager Jr.?
Yes, Your Honor.
And Mr. Seager, the best you can, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You can put your hand down. Will your client waive the formal reading of the motion?
He does.
So let's just go through that motion. Mr. Seagrist, in cause number 25, DCCR 1836, I have a motion to revoke your community supervision. Shows that you were placed on probation May 18th of 2026 for burglary of a habitation, and that was a 10-year sentence that was probated for 10 years. Is that correct?
I thought it was probation for 5 years.
Shows 10.
It was 10. It was 10 years.
It was 10?
Yes,
I thought it was 5.
Okay. So it looks like it was for 10. And then it alleges that you violated your probation. The only count is count 1. It shows that you violated the conditions of your probation by attempting to contact the victim of the offense, Perla Munoz, through the smart communication messaging system at our jail, May 26th of 2026. And is that true or not true?
It's true, Your Honor.
Did you enter your plea of true to count 1 freely and voluntarily? Is there another?
he's right, Judge.
Is it 5?
Rated for 5.
Okay.
Till for 5.
Okay. Well,
I had to double check it 2 places, and it's 10/5.
okay. Thank you. Well, thank you for bringing that up. Does the state wish to amend that motion?
Yes, Judge.
Does any objection to
Okay.
that amendment?
Line for the second 10 and like 5.
Yeah, that's easier said than done on a computer.
Like, you go paperless, it's all going to be easier and better.
It's also like the tiniest writing ever. Okay. So 10-year sentence that was probated for 5 years. And did you enter your plea of true to count 1 freely and voluntarily?
Yes, Your Honor.
And did you plead true to that count because it's actually true?
Yes, Your Honor.
And so it's my understanding that you guys have reached an agreement, Mr. Smith and Mr. Lewis.
Yes, Judge. He's just started on probation. We would ask that the court admonish him that he cannot have any contact with Mr. Munoz, and that we will we've offered to keep him on probation, make sure he's on the mental health caseload, stays on his medication, and has no contact whatsoever.
So, Mr. Seagrist, I have a feeling we probably talked about this at sentencing, that you weren't supposed to have any contact or communication with her. And 8 days after you contacted her, or at least tried to, you are going to end up in prison if you do it again. We will not be here with anybody saying, let's give them medication, let's help them, let's put them in programs. I'm not going to hear it. If you try to contact or communicate with her in any way, you're looking at minimum 2 years up to 20 years in prison. And I'm going to take it very seriously. I can tell you that. Do you understand?
Absolutely.
So whatever the relationship was, it's done.
Yes, ma'am.
And there's no reason for you to ever talk to or communicate with her again. If you do, you'll go to prison.
The court found the probation violation true, but chose not to revoke probation. Instead, the defendant received a 45-day jail sanction and was ordered to have absolutely no contact with the victim. The judge also directed him toward probation and possible mental health treatment to help him avoid making the situation worse.
It's that simple.
Yes.
Okay. So I'm going to find that you entered your plea of true to count 1 freely and voluntarily, find that count true, find sufficient evidence to revoke your probation. I'm not going to do that. I'm going to continue you on probation. Again, same condition, not to have any contact or communication. Any issues, you'll be on the mental health caseload if you need any help with whatever it is. Probation's there to help you do that. Okay.
Yes.
Yes.
I was wanting to ask you, if I could have any access to like a mental hospital or higher release, like after I get released.
talk to probation about that as soon as you're released,
Yes.
because they have options. And if there's something that they can find for you that's inpatient, it's hard to find some inpatient. There's outpatient stuff that you can do. You need to, but there might be something that they can do. You need to talk to them about that immediately. Okay.
My probation officer?
Yes.
Okay.
As soon as you get out and you're released from custody, go straight to probation, make that appointment, talk to them, explain that you feel like you need some help up front, so that you can be successful later. And I'm sure they'll do everything they can to do that.
Yes, sir.
Okay, thank you.
you.
Go back with the bailiff. And Jody, if you'll just make a note to let his probation officer know that,
Officer is not officer.
okay,
So,
that what he's asking for is, thank you.
Judge, could you pronounce the 45-day jail sanction in this case?
Oh, you didn't say that out loud when he was standing there. Y'all might have said ahead of time.
Yeah, we said it ahead of time. We said it was a 45-day jail sanction.
With credit
With
for any time?
Yeah.
So there will also be,
He's still got another 2 or 3 weeks to get to serve.
right, yeah.
yeah, just play. There you go. Big judge needs you.
Yeah, so Mr. Seacrest, it was also part of that agreement or recommendation that you serve a 45-day jail sanction as a part of that for you violating the probation. So I am going to order the 45-day jail sanction. I think you have some time left on that. You can have probation. If you can have them maybe go out there while he's there so that as soon as he gets out, maybe there's something in place. That would be great.
Okay.
Thank you. All right, you can go back with count one, the first degree, or
Count one, the lesser included. We weren't sure which one to mark, so we went both.
okay. Lesser included of
Robbery.
Right. And he will have a hold from Liberty County and proceed there.
and it'll be the second degree.
Yes.
Yes.
All right, so are you David Hale?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment?
Yes, Judge.
Mr. Hale, in cause number 26 DCCR 0106, the state has elected to proceed on count one only, and in that count to the lesser included offense of a second degree felony robbery from December 15th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1.
Yes.
Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tender number 1,
No objection.
it's admitted. Is there any evidence that Mr. Hale is not competent?
No objection.
All right, sir, I'm going to find that you entered your plea of guilty to the lesser included offense in count 1 freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the second degree felony offense of robbery. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir.
This hearing ended with 2 very different outcomes. One defendant remained on probation after receiving a serious warning and jail sanction. Another entered a guilty plea and received 6 years in prison. Together, the cases show how quickly courtroom consequences can change based on the facts, pleas, and agreements before the judge.